Hi everyone, I'm David Weber, broker and operating manager of State Property Management, serving Orlando and the greater Central Florida area. If you're a landlord or property owner in Florida, you may have heard of some chatter about a new law that went into effect on October 1st, 2025, and it's one you can't afford to ignore. It's called Senate Bill 484, and it changes what landlords are required to disclose to tenants regarding flood risks and flood history at the property. Now, before we dive in, let me be clear. I'm not an attorney, and this video is not legal advice. If you have questions about specifics in your lease or your situation, you should absolutely consult with a qualified real estate attorney. That said, this video will help you understand what the law says, what you are and are not required to disclose, how this applies to Central Florida properties, and what we're doing here at State Property Management to stay in compliance. Now let's dive in. Senate Bill 484 is a new flood disclosure law passed in 2024 and became effective October 1st, 2025. It's designed to make sure tenants are informed if the property they're renting has flooded in the past, is it in a designated flood zone, or carries a known risk of flooding. For years, landlords in Florida weren't required to say much about flood risk. This law changes that, at least in writing. If you're renting out a property in Florida, you're now required to disclose the following in writing to a tenant before the lease is signed. 1. Whether the property is located in a FEMA, Federal Emergency Management Agency designated flood zone. 2. Whether the property has ever experienced flood damage due to a natural event, like heavy rain, hurricanes, or storm surge. 3. Whether flood insurance is in place on the property. 4. A general flood risk disclosure that includes statements like flood damage is not covered by a basic renter's insurance policy. You also may wish to obtain flood insurance coverage on your own. Now you might be thinking, this makes sense for the coast, but I'm in Orlando. Does this even apply to me? Well, yes, it does. Here in Central Florida, we may not deal with storm surge, but we do deal with flash flooding, overflowing retention ponds, saturated lots, and rising water tables during hurricane season. In fact, some neighborhoods in Orange, Seminole, and Osceola counties are in FEMA special flood hazard areas, and many owners don't even realize it. So even if you've never had a flood, if your property is in a flood zone or has experienced water intrusion in the past, you may now be required to disclose it. Now, if you're a landlord trying to keep up with new laws like one, you're not alone. At State Property Management, we've already updated our lease templates, pre-lease disclosures, owner onboarding forms, and our internal compliance process. We make sure tenants receive and acknowledge the flood disclosure before signing the lease, and we document everything digitally. It's just one more way we help property owners stay protected, stay compliant, and stay ahead of the curve. If you'd like help, visit www.managecentralfloridaproperty.com and schedule a free consultation. Now, this is the big question. What happens if I don't disclose? As of now, the law does not impose fines for failure to disclose, but that doesn't mean you're in the clear. If there's a flood and the tenant claims they were never warned, and it turns out the property was in a known flood zone or had prior damage, it could open you up to civil liability, be used against you in court, or make it harder to enforce the lease. That's why we recommend not only following the law, but being proactive and transparent, and contacting an attorney for advice before making any decisions. If you're self-managing or working with another company, here are a few simple steps to protect yourself. 1, check your flood zone status. Use FEMA.gov or your county GIS mapping tools. 2, add a written flood disclosure to your lease package. Don't rely on verbal communication. 3, document any past water intrusion or insurance claims. 4, consider flood insurance, especially if you're in a low-lying area or near retention ponds. And 5, educate your tenants. Let them know that renter's insurance usually doesn't include flood damage, but they can purchase coverage separately. And of course, always stay in sync with your property manager or real estate attorney to stay compliant as new rules emerge. Florida's rental laws are always evolving, and SB 484 is a reminder that being a landlord today means staying informed. But the good news is, A few simple updates to your lease and processes can go a long way in protecting both your tenant and your investment. If you're looking for a management company that keeps you ahead of these changes and protects you from risk, give us a call. Visit www.managecentralfloridaproperty.com to book a free consultation and see how we can help. And if you found this video helpful, don't forget to like, subscribe, and hit that notification bell so you never miss another tip. I'm David Weber from State Property Management. Thanks for watching, and we'll see you in the next video.